the biggest question I get asked is currently is whether the circumstances of a particular workplace will allow the employer to stand people down without pay. And frankly, the Fair Work system under which most private sector employers in Australia are operating does not really recognise the right to stand people down without pay because of the circumstances they're all facing. Now, there are some exceptions to that. If your business is affected by the prohibition orders that will come into effect tonight, or the earlier prohibition orders that effectively destroy your business model or your ability to trade, thinking pubs, clubs, gyms and the like, and now some beauty services and so on, those employers can stand their people down without pay because there's a stoppage of work for which the employers aren't reasonably responsible, and by and large there's no other work that people can be provided with. But beyond those circumstances, most of the rest of us are just affected by very dramatic and sudden economic downturn, and so it's not at all clear, and in fact if you look at the guidance published by the Fair Work Ombudsman, it's certainly not clear at all that employers caught up in the dramatic economic downturn can simply stand people down without pay. So that then leaves employers and their employees left with some very difficult decisions about what to do. I mean, the most draconian thing that can occur is employers will have to dismiss people on redundancy grounds, which of course commonly occurs for economic reasons, but we'd be facing another epidemic, if you like, of people losing their jobs and employers incurring enormous costs of termination associated with redundancy packages and the like. So in between those two options, it's all about trying to reach agreement with your people. And everyone is being asked to make very difficult choices. I think you can take some sort of comfort or at least guidance, if you like, from what Qantas announced last week and what other employers are talking about doing. So the types of things that Qantas was saying that it would allow people initially to take their annual leave entitlements, their paid long service leave entitlements, some paid leave entitlements in advance, although not all employers will be able to offer that, and some employment entitlements at half pay, although the Fair Work Act doesn't really contemplate that as a default position. And then, of course, you can negotiate with your staff for reductions in working hours and pay, which generally has to occur by agreement. It's not something that employers can simply force on their people. The Fair Work system is moving. It's very reactive at the moment, and a lot of employers are caught up in a difficult spot with no options. But yesterday, for example, in the hospitality sector, the Fair Work Commission made a determination varying the hospitality award. Some would say it's too late, the horse has bolted, because a lot of those people employed in that industry are now out of work already. But that award was modified to allow additional flexibilities, and among other things, employers in that industry can now, after consulting with their people, direct their staff to work reduced hours down to 60%. They can also redeploy them across other duties, provided people are competent to perform them. So the system is moving, but there's a lot of lack of flexibility and a lot of employers in a very difficult spot.
Clearly the Fair Work Act was not designed to deal with a situation like this, because it is unprecedented, it's extraordinary, it's all the superlatives we've been using. But what comfort can we give employees if they do agree to these kind of circumstances to keep themselves in a job, to keep the business going, that will return to normal after the pandemic, that we're not going to be faced with a situation where wages are constantly lower, where their rights are taken away and they just don't come back?
Well, I think that a lot of that is just going to be driven by what happens in the economy. If an employer and an employee agree for the employee to take a period of time out from work, including a period of non-payment, well, they're not dismissed. they'll keep their employment. For how long that goes on, we'll just have to wait and see. At the end of it, it may well be that some employers just won't be coming back and will be forced to dismiss people on redundancy grounds. So in some businesses, it might just be a matter of kicking the can down the road. Others, it will depend on their capacity to come back according to what goes on in the economy. And you've got to maintain, I suppose, unless you're dismissed as an employee, there's always the potential for a return to normality or some semblance of it.
Now, you referenced in your first answer just the need for greater flexibility. Is this something the Fair Work Ombudsman can do by regulation, or is this going to need to be done by laws passed through the Parliament? Because we know that's not happening anytime soon now either.
That's a very interesting question, Annalise. For example, yesterday the order made by the Fair Work Commission in the hospitality sector was made upon the application of 2 unions, I think, in that sector, but there was no argument that those additional flexibilities needed to be built in, and that was by order of the Fair Work Commission. So was there a change in the law? Yes, there was. It was, I guess, a form of subordinate law, which the Fair Work Commission has the jurisdiction to do by changing the award system to introduce, and they only introduced that temporarily for 3 months to provide that additional flexibility. So there is the jurisdiction of the Fair Work Commission to amend awards, which does in effect change the law. In relation to the power or the right of employers to stand down without pay, there's just a great deal of uncertainty about. For example, I have an employer who is in the new car and used car business. Now, they're not subject to an enforceable government determination or public health order that they have to close. But their business model has been diabolically disrupted. The Prime Minister was on television last night saying, well, look, if you don't need to go out of your house, then don't. So very, very few people are going to race down to their nearest car dealership to buy a car. So that particular employer's business model is incredibly disrupted, if in fact they're functioning at all. And yet the Fair Work Act does not clearly give them the right to stand down employers without pay. The Fair Work Act, in the view of the Ombudsman, I think if you look at the Ombudsman's webpage, is that that's an economic situation, albeit one that applies to all of us massively and quickly, but it doesn't authorise a stand down without pay. So there's 2 possibilities, I think, for intervention there. One is some legal reform, although I don't know how that will be possible given that the Parliament isn't coming back to make new laws for the next 5 months or so. Or it may be that, and some employers will take a more aggressive posture and try to exercise the right to stand down without pay, and the Fair Work Commission will then be brought into a dispute effectively between that employer and its employees or a representative union, and it will have to make a call on whether or not, in that particular fact scenario, the employer could properly exercise the right of stand down without pay, despite there being, no direct government edict requiring that particular business to shut down.
Andrew Tobin, thank you so much for your time. These are really important questions for so many employers, and we'll hopefully have you on again soon to talk about the latest as more people join the unemployment queue.
Okay, thank you.